Hi, this is John Morris, the president of the Utah chapter of the Community Association Institute. Welcome to the webinar tonight. The topic will be an update on the new HOA laws passed in 2015. These laws will start taking effect on May 12th and will all be enforced by July 1st. The presenters tonight all participated in the drafting of these laws as members of the UCCAI Legislative Action Committee. So this is a great opportunity to hear about these new laws from the people who really have insight into the reasons for the laws and the drafting of the laws. I have a few quick announcements. First, thank you to the local chapter Diamond sponsors, Weill Fotheringham, Advanced Community Services, and Morris Sperry. Thanks to the event sponsor tonight, Morris Sperry. Morris Sperry is my law firm. We are the only law firm in the state of Utah focused entirely on HOA law. We serve hundreds of associations, owners, and developers of community associations. We handle all legal services an association might need, including CC&R rewrites, general corporate advice, collections, litigation, and construction defect cases. We are proud to sponsor events like these that help educate board members and owners in the state of Utah. Thank you, and let's get started.
Hi, I'm Bruce Jenkins. I'm with Weill Fotheringham down in St. George, and grateful to share with you some of the legislative updates. Tonight, I'm going to be covering updates on rental restrictions and rules governing rentals, and also talk about reserves. And I'm also a reserve specialist, so with reserves, they have a special place in my heart, and I think that's an important change in the legislation for this year. But let's go ahead and start with the rules and how they affect renters. This issue with renters came up last year at about this time with the apartment association calling me and saying, Bruce, we don't like how associations are treating renters or owners who rent their units, and we have a real problem. We would like you to work with us in drafting some legislation that would help correct some of those problems. And so we began some dialogue, and the discussions at some point got a little bit rocky and challenging, to the point where some people walked out of meetings. But we got back together, to the credit of everyone. The Apartment Association was good to work with. Jason Suker, John Morris, and myself all had negotiations with the Apartment Association, and we addressed their concern. One of their concerns was that associations were charging extra fees to rental owners just because they didn't like renters. No additional justification. There might be a move-in or a move-out fee charged to a renter, but not charged to an owner who would move in or move out. And so what we did is made amendments in two places. The first one is in the rules and regulations. That would be sections 57.8, 8.1 of the Condo Act, and 57.8A to 18 of the Community Association Act. Now, 57.8, 8.1, that is an entirely new section. It's not an amendment to an old section. It's an entirely new section introducing association rules in condominium context. 57.8A 218, it's an amendment to that already existing section. What we did to work with the Apartment Association was provide that no rule can treat the unit owner of a rental differently from any other unit owner, with three exceptions. The first exception is that a rule may prohibit the owner of a rental unit from using common areas except to attend association meetings or to manage the rental unit. Second, because sometimes owners want to rent their unit and still use the clubhouse and the pool, if that's the case, then the second exception will allow the association, by rule, to charge a fee to that owner for the right to continue to use the common areas, even if that use is only occasional. The third rule that can govern rentals differently than other unit owners is that the governing documents, again, you have to amend the governing documents. You have to have somewhere in a governing document a requirement that the tenant will abide by the governing documents of the association, and that if the tenant violates any of the governing documents, then the tenant and the owner can be held jointly and severally liable for that violation. Now, that's a significant change, and that was a significant concession by the apartment association to provide for joint and several liability. That allows associations where you have an out-of-state owner that you can't reach and maybe can't get in touch with to enforce the governing documents against their own tenant. You can now, if you provide for it in your governing documents, move jointly and severally against that tenant for that violation. If you're going to do that, however, make sure you give the tenant the same process that you would give the owner: warning, notice, right to a hearing. Don't just give the notice and the warning to the owner and then think that you will tag the tenant for the cost without giving the tenant any right to the process. Those were significant things. The other thing the apartment association, again, did not want is for excessive fees to be charged to rental owners. As I mentioned before, they were having struggles with move-in, move-out fees. So in the existing rental restrictions, 57.8-10.1 in the Condo Act, in 57-8A, 209 in the Community Association Act, in both of those places, we included a provision that an additional assessment, fine, or charge cannot be levied against a rental unit owner simply because he rents his unit. So that is really treating all occupants fairly. If you're going to have a move-out fee, charge the move-out fee to everyone who moves in or out. The additional thing with rental restrictions that was done this year is previously, if an association wanted to impose a rental restriction or rental prohibition, for example, place a cap on the total number of rentals available in the association, you would not have to comply with the provisions in 57.8-10.1 or 57.8A-209 if your initial declaration was recorded before May 12th of 2009, meaning that an association with declarations recorded prior to May 12th, 2009 could impose rental restrictions without including certain statutory exemptions or without following the amendment process outlined in those code provisions. However, beginning May 12th of this year, any amendment to any declaration, no matter when the declaration was recorded, even for those recorded prior to May 12, 2009, if a declaration is amended to include a rental restriction and a prohibition on rentals or the number of rentals, then the association must comply with these code provisions and also must include the statutory exemptions from rental restrictions for military service or occupancy by a parent, a child, or a sibling, job relocation, or an estate planning document like a trust where the resident or the parent, child, or sibling of the resident is occupying the unit, even though they may not personally own it, but the trust owns it. Those exceptions would mandatorily have to be included in those rent restriction amendments. Now, the next thing that I want to talk about is reserves. And as I mentioned earlier, reserves are an important issue for me, and I think they're important for the association. It's important to keep a capital reserve so that when it's time to make repair and replacement of capital improvements, the money is on hand to do that to avoid a special assessment. Now, this particular bill, HB 80, it amends 57.8, 7.5 of the Condominium Act and 57.8A to 11 of the Community Association Act. As introduced, that bill would have done a couple of things. One, as introduced, it would have required all developers to take 30% of the assessments levied and put in a reserve account. The next thing it would have done is only allowed the money in that reserve during developer control to be used to pay for a reserve study. Although the concept sounds good, there are some problems with that, and the LAC ultimately opposed that, as did developer groups, because if money is being placed in reserve, even during the developer control period, and, for example, roads need to be resurfaced, it would seem odd to have money built up in a reserve account that you could not then apply to the roads while the developer was in control. That didn't make sense. Also, the 30% blanket assessment doesn't necessarily have a rational or reasonable basis. It sounds good at first blush, but it might be too little in some associations. It might be far too much in others. So the bill was modified, and now it provides, instead of a certain percentage of assessments being held back, it has become a notice provision. And it's a notice provision that only applies to developers who record their declarations from and after May 12, 2015. Now, why then? The developers in the past have always required that they are exempt from any of the reserve requirements in the Condominium Act and the Community Association Act. They did not want those requirements applying to them while they were in the control of the association. So that scheme is not disrupted, these provisions that I'm going to tell you about in just a second about disclosure will only apply to new associations with the declaration recorded on or after May 12, 2015. Here are those things that the developer must do after that date. When selling a unit, the developer must provide a copy of the association governing documents, and the developer must provide a copy of the association's most recent financial statement, including any reserve funds held by the association or some subsidiary of the association. The great thing about these disclosures are now a purchaser will be able to have a better idea when looking at one association and another if he can compare apples to apples. For example, you might look at one community on one side of town and their assessments might be $100 a month, and they have a pool and a clubhouse, and then you look at a community on the other side of town that has a pool and a clubhouse, and the assessments are $150 a month. And you're thinking, boy, I like the cheaper product. I will buy the cheap one. It's kind of like my wife and I when we go to the grocery store. I look at the labels and I look at the prices, and I always buy the cheapest can of whatever we're looking for. And she will look at me and say, I don't like that brand. I want the more expensive brand. And so we get the more expensive brand. But in the association, what this disclosure will now let someone do is look at the financial statement and the amount in reserves and say, boy, the association that only charges $100 a month in assessments doesn't have a very large reserve. I might be at risk for a special assessment if I buy there. The other association, on the other hand, charges a little bit more, but they're more financially sound. I think I might want to buy there. And at least the purchaser now will be able to look at that and make an educated decision. Now, lest one think that developers of associations prior to May 12, 2015 have no obligation to conduct reserve studies and set aside a reserve. There is no statutory requirement to do that, but there is case law requirement. In 2009, the Utah Supreme Court, in a case called Davenport, required of developers a number of fiduciary duties. One of those fiduciary duties was to establish a sound fiscal basis for the association, and as a part of that, to provide for an adequate reserve. So even now, under the current common law or case law, a developer has an obligation to fund reserves that would take care of the financial needs of the association during the time that the developer is in control and before the developer turns over control to the homeowners.
Everybody, this is Michael Johnson, CEO and President of FCS Community Management. I've been asked to moderate tonight's session. A couple questions have come in for Bruce Jenkins regarding his presentation. The first question, Bruce, is in our condominium, renters only have to sign a 6-month lease. So renters are moving out a lot more than owners. They're causing a lot more wear and tear. How do we recoup these costs?
Association is that they can charge all occupants who move in and out the same fee. And when I say all occupants, if it's a renter that moves in or out, there is a fee. If it's an owner that moves in or out, there is a fee. As long as there's consistency in the amount charged to the occupant who moves, whether it's a renter or an owner, then they should be fine.
Okay, great. Our next question says, can an owner-landlord expressly not give their common area amenity rights to a renter tenant, keeping them for themselves? So I believe this question's asking, if I'm an owner and I rent out my property, can I keep the right to go to the property's pool and weight room and clubhouse to myself and not have the renter have that right?
I would say yes, because it's a matter of the contractual relationship between that landlord and that tenant. It just becomes difficult to enforce. How do you tell a tenant and a tenant's children and their guests that the nice pool they can't get into? So it would be, I guess, good if the association had a key fob or something that the owner would keep and not give a duplicate to his tenant. But as a rule, if an owner wants to keep those rights to themselves and not assign those rights to a tenant, he could do so.
That would be through the lease or the agreement between the owner and the tenant, not through the association documents in any way.
Yes, thanks for pointing that out. That is true, because if you look at the association documents, you might find that a tenant could have rights under the owner unless the owner restricts those rights through the lease agreement, and those restrictions should be spelled out very specifically.
So the Act contemplates the association in a typical example where tenants moved in and they have the rights to use the clubhouse and the pool and everything. That's how it typically works, and the new law allows for associations to still allow that owner to keep coming and using the common area facilities, such as a pool or weight room or a clubhouse. So possibly if you switch things around, the association could come up with a fee that would allow for the tenant to use those facilities.
Correct. So that the idea behind this was not to have excess use of the common areas when there's a tenant there. so that if the tenant and the owner are both going to be utilizing the facilities, then there can be a fee, say, charged to the owner or the tenant. It would eventually come out of the same pocket, I guess, or out of the same transaction. But there could be an additional fee charged for the additional use of the clubhouse now that you would have two groups, the owner and the tenant, making use of that same facility.
Would you have any problem with an association passing a resolution that said any unit that rents will automatically be charged this fee that will allow both the owner and the tenant to use the facilities? So it'd be mandatory for all of them, not just for all rentals, not just a one on one basis.
That is a great question. I probably would. I think of the owner who lives out of state and will never use the facilities and has it solely as an investment and would feel targeted. I would probably not pass a blanket resolution. And I say that, however, depending on the association, because if the association is small, can't afford the administrative expense of trying to deal with those owners who want to continue to use and those owners who have given up the right to use and assigned it solely to the tenant, there might be some situations where I could justify a blanket rule. Otherwise, I think I would, if possible, write the rule such that if an owner elects not to use the facilities, he's not charged an additional fee for the common facilities.
All right. Bruce Jenkins with Weil & Fotheringham in St. George. Thanks for participating tonight.
My pleasure. Thank you.
All right. Our next presentation will be from John Morris, who introduced tonight's session to us, and we'll go ahead and get that started.
Okay, welcome to the next session of the webinar. My name is John Morris. I'm an attorney with Morris Sperry, and I'll be presenting on the next three bills, HB 99, HB 304, and SB 2118. We'll just dive right into it and try to keep things moving along. The first bill you can see on the screen is HB 99. If you don't already know about this tool, you can get copies of these bills and a lot of information about these bills on the Utah Legislature website. And you can see the link up here, up in the upper left-hand corner. You just type in Utah Legislature, and they have a great website. It'll come up. You can go to the bills for 2015 and find any bill that you want to find. So what you're looking at is the screen that pops up when you find a bill, and the bill text is here. There's status that'll show all the committee hearings, everything that happened with the bill, the voting over on the right. You can drill down on that and find out who voted for, who voted against if you want. And then, of course, to the end here where you see the governor's signature date. Also, you can listen to committee hearings if you want to on this screen about these particular bills and see what was discussed in committee. And also occasionally you'll see floor debates, floor video, things like that. You pull all that up. It's a super helpful tool to keep track of any legislation. So what we're looking at is HB 99. HB 99 was a long collaborative effort by the participants in the community association industry. The local CAI chapter spent a couple years working on a bill that would essentially require associations to open meetings to homeowners in HOAs. This bill came about because, notwithstanding advice from just about everybody in the industry, managers, attorneys, people who are trained in good practices, that you should open meetings, some associations still don't open meetings. And even to this day, there are associations who refuse to allow owners to sit in on board meetings, and not just executive session meetings, but all meetings. And generally, in our industry, that's recognized. That's not a very good practice. It creates problems. Owners get suspicious. They want to know why they're being excluded. And more often than not, there aren't any real problems with the operation of the association, but people just think they are because they're excluded. So because of that, the industry started getting together and talking about a bill like this. And last year, the bill was finalized, made it through the House, and just ran out of time. So this year, it was ran again, and it was passed with plenty of time. This bill has a couple of important components. The first thing, obviously, is it requires regular board meetings to be open to members of the association. Now, there are exceptions. If there are emergency meetings, you don't have to give notice to owners. You can have meetings. You can still do business outside of meetings by email or other proper methods, and you would not have to open those discussions to owners. But when you have a regular board meeting, it does need to be open to the owners. In addition, you must allow a limited time for owners to speak and make comments at the meeting. Now, this is an important point because it doesn't require owners to participate in your meetings. They don't get to sit down at the table. They don't get to comment on business as it's occurring. They have the right to attend and watch. And during this specified time, they have the right to give comments and ask for feedback or ask questions, whatever they want to do during this time period. We see boards do that frequently at the beginning of the meeting. So that if there are any owners present, you welcome them and you invite them to make a comment, and they can talk about whatever issue they want to talk about. You can choose to respond then. Boards can choose to say, thank you very much for your comments. We'll get back to you on that, or we'll take it under consideration. And then you move on with the business of the meeting. And during the rest of the meeting, owners have the right to attend and listen, but they certainly can't be, do not have the right to interrupt or make comments. The next important part of this bill is you can certainly close the meeting for executive session. There are certain times when boards need to have meetings, and they really need to, those meetings need to be limited to just the board members and sometimes key advisors such as their attorney. So some of the reasons you can close a meeting for executive session, and these are all outlined in the new law, is to consult with your attorney, to discuss litigation, to discuss a personnel matter, for contract negotiations. And where we see, like this contract negotiations in particular, occasionally you'll have owners who are interested in something. Maybe one of your owners knows the landscaper who's submitting a bid, and that owner wants to come to the meeting and listen to the board talk about that bid compared to others. And you have concerns about whether information can be leaked or to one bidder versus not another. You might close the meeting for that type of discussion. Another thing is you can close a meeting if the board determines that whatever you're about to talk to might embarrass an owner. So, for example, let's say there's a complaint that an owner in the association is running naked around the neighborhood or is wandering around their house naked and people are looking in the windows, which this happens once in a while. And you might close the meeting to have that conversation because you wouldn't want to embarrass that neighbor who's essentially accused of doing something like that. The other thing you can close the meeting for is to discuss delinquent assessments. Boards can close the meeting for that purpose. Now, it's important to remember boards can close the meetings for these reasons, but they don't have to. And other than discussions with your attorney, where there might be an attorney-client privilege issue, a lot of these other matters, if you don't have an interested owner or somebody who might create problems with your discussion, you might leave those open, and you might discuss all these issues in front of owners and not close meetings, and that's left up to the discretion of the board. The next most important part of HB 99 is you must now, for the first time, as a matter of law, provide notice of regular meetings to owners if they request notice and provide an email address to provide that notice. Now, a lot of debate and discussion went into this part of the bill. And at a high-level view, this was absolutely necessary to allow proper attendance, because allow owners to attend. If they don't know of the meeting, then how can people attend? They obviously can't. So there had to be some notice provision. Now, in other states, this notice provision can be pretty onerous. Occasionally, you'll see bills or laws that require owners notice to all owners of every board meeting. And a balance was struck on this issue, and it was decided that this particular notice provision wouldn't put too much burden on associations, but at the same time would allow for meaningful notice. So where we ended up was, if an owner requests notice and they provide you with an email address, then you must provide notice for regular meetings by email, which is, of course, is a very low-cost way of providing notice. And remember, once again, you're only providing notice to those owners that request it. And there, of course, was debate about some owners may not have email, and this could exclude them from this requirement. But on balance, it was decided most people either have access to email or know someone who has access to email in this day and age. And so this was felt it was an effective way to give notice. So the law requires that you provide notice at least 48 hours before the meeting. Obviously, there are exceptions for emergency meetings where board members have less than 48 hours. And once again, this would not apply to business that occurs outside of normal meetings. There are more details related to this bill. It's a good idea to, once again, jump online and read the bill. It's very easy to find on the legislature. The bill is fairly easy to read. It has some good provisions. It's not that long. This is the body of it here for the Condominium Act, which is 57.856. And then there's a nearly identical version in the Community Association Act under 57.8A in this same bill. So with that, I will move on to the next bill. And the next bill to talk about is HB 304. Once again, HB 304 is available on the Utah Legislature's website. You can come to this page, scroll down, and it'll give some definitions here in the definitional section that changed, and then here's the body of the bill. 57.856 is where the law will end up. This bill will take effect on May 12th. HB 99 had a delayed date. I think it was July 1st of 2015 when that will take effect, but HB 304, which is what we're looking at now, will take effect on May 12th. This bill was sponsored by Representative Pitcher in the House and Senator Shiwazawa in the Senate. Representative Pitcher and worked closely with the LAC. This is another LAC bill, a Legislative Action Committee out of our local chapter of the Community Association Institute. This bill has one primary purpose, and what it does is it's to protect damage to associations from freezing pipes. And the scenario that we're running into is, at least I hear about half a dozen of these every winter. Sometimes it's worse or more, but either as a result of a foreclosure or some other reason, people will move out and abandon their units. And they quit paying the utilities when they do that, specifically the gas and the power bills. And when that happens, the utility companies will turn off the utilities. And now you have a unit in the middle of the winter that has not been winterized. There's no heat. And what will happen is the pipes will freeze. And then when you get a warm up for whatever reason, those pipes that have frozen and split because they've frozen will warm up, and then you get a flood. And unfortunately, it's not usually just the unit that freezes that gets damaged. It's neighboring units in community associations that also suffer damage because of this. So what this bill is designed to solve that, or help solve that problem. Now, how it helps solve that problem is associations now have the right to send a notice to the gas company and the electric company, giving them the addresses of each unit in the association and the address of the association for notice, and asking for notice. Then, after that notice is provided, the utility company must provide notice to the association before they shut off utilities, yes, it's just gas and power, to any unit in that association. It has to be 10 days of notice. Now, what that allows is the association to try to figure out if there's a problem, if the unit's abandoned, and then also take action to either winterize the unit. So you enter the unit and drain the toilets, do the things you need to do, turn the water off so that the pipes don't freeze, or pay the utilities. And so that so the heat stays on. And that's HB 304. All right, so the next bill we're going to talk about is SB 218. And once again, looking at the Utah Legislature website, you can see SB 218. It's changes to the Revised Nonprofit Corporation Act. The Nonprofit Corporation Act is applicable to about 95% of associations because they're organized as nonprofit corporations. So we have to pay close attention to this act for procedural guidance and rules that apply to associations. And it's important to understand a lot of provisions in the Revised Nonprofit Corporation Act will defer to association bylaws, but many don't. So we are always looking at the Revised Nonprofit Corporation Act and figuring out if there's some procedure that we need to comply with that might not be in our bylaws. Now, SB 218 has a lot of amendments. The bill just seems to go on and on and on, and a lot of them are technical amendments, and a lot of them don't impact community associations in a really meaningful way. So what we're going to try to do is focus on a high-level look at this, talk about some of the ways that it will impact community associations. Now, the first important point, I think, is there's a lot of the technical changes in the Act are designed to facilitate electronic communications. So communications by text and email are explicitly acceptable in more circumstances. So, we just need to pay attention to that concept that more and more notices and communications by text and email will be valid from a procedural standpoint in running your association. The next point is this bill clarifies that a substitute proxy may be sent electronically, including by text and email. And that can be an important point in an annual meeting. Not too long ago, I was at a meeting and we had someone attempt to assign a proxy by text. And I was stuck trying to answer that question. As it turned out, the text, we were unable to see who the text was from for some reason. So and luckily the proxy didn't matter in the election, so we ultimately didn't have to get to the bottom of it, but there were definitely issues about whether that would have been a valid proxy or not. So the statute has clarified that a substitute proxy may be sent electronically, including by text and email, which means if someone has a phone in front of them and you can look at the screen and tell who the text is from, and you don't need, the days of real signatures are long past. If someone shows you their phone and claims that they have a text from an owner with a substitute proxy, which would be replacing a proxy that's already been issued, unless the association has a reason to believe that's not accurate, that is a valid proxy. Now, in the case of proxies by text, you probably want to be careful with that. And if it turns out that proxy could turn the difference between one vote or another, you might want to go back and verify with the owner who sent the text that it really was. But if you have no reason to doubt the validity of the proxy, that can be a valid proxy. So associations will have to figure out how to memorialize those proxies, which would probably include, the easiest way would be for someone to take their cell phone and take a picture of that text, and then you would verify that picture and keep that picture in the association's records. And we're going to be working through, I'm sure, in the future, more and more issues related to these electronic proxies. But what you need to know is the Nonprofit Corporation Act is headed in that direction full steam, and we're going to have to figure this out because those proxies are valid. The next big change that will impact community associations is changes in the procedures for how boards do business by text and email, specifically email. And we all know that association boards are doing a lot of business by email. The reality is a lot of that business is not being done properly. Those decisions are not proper under the revised Nonprofit Corporations Act, and they're subject to problems for challenge. You can tell that the changes in this bill, SB 2118, are designed to make that easier. So those associations that are not doing things, I would say most associations that aren't aware of the revised Nonprofit Corporations Act, a fairly high percentage of them, probably 90%, maybe even higher, are not doing business properly by email. Under this bill, that might drop. Maybe only half will be doing business improperly if they're doing it by email and not paying attention to the act. But you can tell that the changes here are designed to make that easier. Having said that, there are still important procedural requirements, things you have to put in the email if you are trying to do business by email as a board. And you can tell, those procedural requirements are designed to protect the right of board members to be heard on issues that they disagree with or that they want to vote against. Once again, important changes for how to do business by email, and boards will need to pay attention to this. And this, of course, will be impacting, almost every association. I mean, you're hard-pressed these days to find an association that doesn't do business by email. The next 3 or 4 changes that could have impact on community associations, there are some clarifications to the notice provisions for board meetings. Once again, moving toward these electronic notices and other reasonable notices that can be valid, that might not have been valid before. It clarified, the additional changes are, there's a clarification to the application of conflict of interest sections to relatives of board members. If you're doing business with relatives of board members, you need to pay a lot closer attention to these conflict of interest sections, and they probably needed to be complied with before anyway, but now it's clear that they do. If you need to do articles of restatement for an association, this clarifies the content of those articles. You can see some changes there to try to deal with some problems that you run into when you're dealing with that issue. And there are many other changes, but once again, I'm trying to hit the highlights. These are the things your associations are most likely to run into, and I'm sure other changes will be filtering through as people are updating and revising governing documents, which they should be doing every once in a while anyway. With that, I will pass the baton on to the next presenter. Thanks, and I'll be around for questions later.
All right, thanks, John Morris. We're actually going to do questions and answers for your session now. And I just want to remind everybody before we get into some of the questions that have come in regarding John's presentation that we had a couple of people ask, where can we go online to get summaries of each of these new bills and how they'll impact HOAs, how that spells out what actions the associations may have to take to comply with any of these new laws. This entire webinar tonight will be permanently available by the beginning of next week on the UCCAI.com website. So that's the chapter's website where you probably found out about this event or through the email from the chapter, UCCAI.com, and this entire presentation will be available for you to review there. Also, the next chapter newsletter that comes out will have written summaries of each of these new acts in a narrative, in a written narrative. So if you'd like to see it in the written word a little more than these audio video presentations, then that's a possibility. All right, let's get the first, and that website should have come up in your chat from our host Spence there in case you have any questions, and it's even hyperlinked. First question, John, is my association board has seen the new open meetings law and said that they will have an owner comment period like they do now, but believe all their topics fall under the executive session, which they don't. What's the penalty to the board for not opening up their meetings, and how do we enforce those penalties?
So that specific issue will be addressed in the next session by John Richards, and the penalty provision is in SB 218. I think it would be best to defer that question until we hear that section. And then if that question comes back, we'll be ready to respond to it with everybody having heard what those penalty provisions are.
Very good. Good tease, too, John Morris. If an owner has made a correct meeting request notification to the association, does the meeting notice the association emails have to include any more information than meeting date, time, and location? Does it have to include the agenda? Does it have to include supporting documents?
No, it doesn't. That was another issue that was debated somewhat, and there are laws in other states that require agendas and supporting documents. The compromise in this bill was that it just has to be the notice of the meeting. The only other piece of information that might be required is if the association intends to allow any board member to participate by telephone or through any other electronic way, then that information needs to be provided in the notice so that the owner can participate that way also.
Yeah, exactly. That's a great point to bring up, that if you allow a board member to participate through teleconference, then you have to allow homeowners to participate through that same method.
Correct.
This is a multi-part question, so I'll ask it in sections. In executive session, who exactly has attorney-client privilege? Obviously, the board does, but can the community manager stay in the meeting with us?
Yes.
Can other office staff that are employees of the management company stay in? So I know a lot of associations, I'm assuming this is part of that question is someone else might come in to take the minutes who's an employee of the management company. Can they stay in?
Yes, I think so.
What about, I know a lot of associations have another homeowner who's not on the board, not an employee, not with the management company. They have them come in just to take, for the purpose of taking minutes in meetings. Would they have attorney-client privilege?
That's a little more difficult, and if that person, so I would have to look at the specific context of how that person is associated with the community. If they are, for example, if they're on a committee or something like that, then possibly yes. But without researching that issue, I would probably ask a non-board member, non-manager employee to leave a meeting where attorney-client privilege was important.
On the fly, would it make any difference if that person was the appointed assistant secretary?
That could, yes.
Okay.
That might make a difference. And if there was some official position and that person was serving the association, then it's possible they could stay.
But we definitely want to make sure that we documented that appointed position before the meeting, not after the lawsuit comes.
Yeah, I think so.
Let's see. Does it make any difference if these managers or employees that are assisting the boards in these executive sessions are employees of the association versus employees of a management company?
As long as they are, you have this what's called a control group analysis, and generally anybody that's involved in the decision making can be included in the attorney-client privilege when you're looking at a corporation, and that analysis is fact-specific. So I hate to give, advice without knowing all the specific facts, but for the most part, that's going to be a fact-specific question.
Okay, and just in the last minute before we move on, what are some examples of times that attorney-client privilege is harmed?
Well, it's called a waiver, and you can waive the attorney-client privilege a couple different ways. The obvious problem, or the most obvious way of waiving the privilege is to disclose the attorney-client communication. So that can happen a couple different ways. If the communication is in writing, let's say the attorney sends a letter to the association or an email with some sort of information that would normally be protected by the attorney-client privilege, and that email is forwarded to another owner who is not part of that control group, that can be the basis for a waiver of the privilege. Another way to waive the privilege is to bring someone else in on a meeting, just like we were talking about. If you have that meeting with the lawyer and you allow a guest to attend who's not as part of that control group, that can be a waiver of the privilege also as it relates to that meeting. I should point out one other thing, and this is a cautious view of the attorney-client privilege, and I'm aware of case law that has pretty clearly said the board has the privilege along with the people in that control group, maybe a manager and others that are involved in the decision making. However, that case said that owners were not included in the privilege. I am aware of recent cases, though, at least one specifically, that held that for a particular type of meeting, owners were included in the privilege. So there may be some issues there, but the conservative view, and what I would always advise associations to do, is keep that control group as narrow as possible and be very careful about emails and disclosing, obviously, what the attorney says, because that can be a waiver of the privilege.
As a professional community manager and owning a management company, my advice to everyone is don't rush these legal type of issues if you have any question at all, make sure that you contact your association's attorney and make sure that you wait to discuss it so that you don't lose the attorney-client privilege. Thank you, John Morris.
You're welcome. Thank you.
All right, we're going to move on with our final presentation of the night from Attorney John Richards.
Good evening, everyone. My name is John Richards. I'm probably familiar with many of you who are listening to this or watching this presentation. I'm going to be talking about Senate Bill 118. I've been with CAI for about 18 years. I currently serve on the Legislative Action Committee with those other presenters tonight. Senate Bill 118, as you can see up in front of you, is a very important and interesting law that is going to affect every association. Many of you have heard about it already, namely the records production requirement that the bill imposes, and also the penalty that's associated with a failure to produce records when an owner requests them. The other part of Senate Bill 118 is to clarify, and we'll get into this in more detail as we go through the presentation, is to clarify the amendment threshold, or the number of votes or the percentage of votes needed to amend your governing documents. And then finally, House Bill 99 will be discussed by another presenter, but this bill, Senate Bill 118, has a punitive or a penalty section for violations of House Bill 99. And House Bill 99 is the open board meeting requirements, and as mentioned, will be discussed by somebody else. So very quickly, just to move on with things, this statute, or this new law, Senate Bill 118, affects Titles 57-8-17 and 57-8A 225. In other words, both condominiums and non-condominiums are bound by this new bill. And to be very concise, the gist of the bill is that associations must keep and make documents available for copying or inspection by their members, the member's agent, which would also include a member's attorney. This begs the question, is this a new law? Have we had this type of law before? And the answer is yes. If you are a nonprofit association, and you have been for forever, then you will already be bound by Title 16, Chapter 6A of Utah's Nonprofit Corporation Statute, and that statute automatically binds you to providing documents to owners if they request them. So this concept of having to produce records is not new this legislative session, but we have some more clarity and guidance as to what happens if we don't produce records in a timely manner. So that's important for any manager or board member to understand what this law means, and that's what we're going to get into right now. So as you can see in front of you, number 2, B as in boy, what documents? What documents do I have to produce? Senate Bill 118 expressly refers to the Nonprofit Act, and you can see we cite 1601, 1602, 1603, 05, 06, 1610. Well, I know that via this conference doesn't do you any good just by name. So let's go through a little bit of what the association is supposed to hold and make available to members at all times. And those matters are, or those documents are, number 1, minutes of all board meetings, minutes of all member meetings. I kind of took those in reverse order there, but records of all actions taken by a committee. So you have an architectural review committee. They should keep records, and those records are now being brought to your attention that those are something that an owner can inspect. And then any waivers or notices of meetings that may have been presented where the board got together and simply send in notice that we waive a notice requirement and we're hereby holding a meeting. Those types of records need to be kept and available for inspection. Again, this is not new, but I'm just telling you what the Nonprofit Corporation Statute already says. As we move on, You can see my caption at the top. Please, still explain what documents are subject to inspection and copying, because that's the question that we as attorneys get all the time. What documents? So on the prior slide, and I'll just back up a little bit so you can see it again. Minutes of meetings, the records without a meeting, those sorts of things, 1 through 4 there. But then moving forward again, here's additional records, appropriate accounting records. You'll note that appropriate is subjective. What does appropriate accounting records mean? So when an owner says, I want all accounting records, that basically means, the industry standard records that any organization will have, a balance sheet, financial statements, income, profit, loss statements, those sorts of things. The question that you'll have to get into with your attorney if an owner makes a very comprehensive financial request is, does the association have to create a record, a financial accounting record, that it does not keep in the regular course? Let's say that somebody wants some complicated report and they have a finance background, and so they say, I want X report. And you know that the manager's computer can produce that report, but the association does not keep that record in its regular course of business. That's a question for your attorney, because based on number 5, appropriate accounting records, I do not believe that the nonprofit corporation statute is asking for you to create records that you do not normally keep, but it is saying that you need to keep records that are regularly kept in the business environment. And so associations, to an extent, are businesses, and to that end, you need to have appropriate accounting records. One thing that may shock a lot of people is number 6, member lists. And it goes so far in the statute, again, the existing statute, to say that names and addresses in alphabetical order showing the number of votes is available to a member upon request. So a lot of times members are hesitant, or association board members are hesitant to give out membership lists because they don't think that's appropriate for members to have other people's contact info. Well, remember, this only says names and addresses. It does not say telephone numbers and email addresses. So we have to provide a membership list, and when you think about the policy behind that, the policy is simply owners are entitled to contact their members to address community issues. Board members sometimes don't like that in case they fear that homeowners are plotting together and scheming together to overthrow the board or to take some other action. But at the end of the day, members are entitled to a membership list pursuant to the nonprofit corporation statute, and now pursuant to the law that's coming into effect because of Senate Bill 118. And I should point out, I guess this is an appropriate time to say that even though the records that we're looking at right now by number 1 through 12 are listed in the nonprofit corporation statute, the Senate Bill 118 goes so far as to say that these records, these issues, these documents, even if you're not incorporated as a nonprofit, are still the documents that you have to produce upon a records request. So you can't get out of this record request requirement or the production requirement by not being incorporated, I guess is the bottom line. Number 7, articles of incorporation. 8, bylaws, resolutions. Number 10 is interesting because it says it's written communication to members generally. So that can be in the form of newsletters or community announcements, which go to the membership in general. That's entitled to be inspected and copied. Number 11, which many of you might not know, is a list of names of the board and its officers, and either a business or home address of the board members and its officers. And that is simply because those who've drafted the nonprofit corporation statute have felt it prudent to make sure that members of an organization have the ability to get in touch with the leadership. So that list has to be available upon request. And number 12, back to financials, all financial statements for the last 3 years kept in the regular course by the association. So there are going to be questions from time to time about, as I mentioned earlier, the scope of financial records that might be required to be produced to owners. And in that case, you're just simply going to have to talk to your manager, but more likely have to talk to your attorney to see if the request that's being made falls under the appropriate financial records that need to be disclosed. This title, this next slide here is, are there any other records we must produce? And as I've mentioned already, remember the documents we've just talked about, they are the ones that are already listed in the Nonprofit Corporations Act. And there's the citation for those who want to jot that down and look at it later. I just feel it's important to have everyone understand that this bill is not adding a new records production requirement that's already in place. This record or this bill just talks about records and what happens when you don't produce the records that are already the subject of production if a request is made before this bill goes into effect. So there's one interesting part to the nonprofit statute that is going to be applicable to all of us now, and it falls under, you can see number 3, 16022. The bottom line is that there's another section of the Nonprofit Corporation Statute that says, in addition to the documents that we've just discussed, and in this presentation it was items 1 through 12, it states that a member is entitled to inspect and copy any of the other records of the nonprofit corporation. This can really cause some heartburn because what is, quote, other record or other records of the nonprofit corporation? And if you look at number 4, I've written here that they are basically anything that the association has in its files. This can be interpreted very broadly: electronic files, file cabinets, even storage sheds. I've had a case recently where the owners requested all of the association's records basically from the creation of the association until present. And frankly, because they had them and because they are deemed other records and because owners are entitled to copy and inspect all other records, we produced them. I don't think we had a defense not to. And that those file cabinets in the storage shed, they had receipts and canceled checks and old contracts and old letters and things received by the association. But if you keep them, they are a record of the association. So you need to talk to your attorney about the scope of records. When someone makes a global record request, talk to your attorney to make sure that you are not undermining the intent of this statute to produce all records of the association. You can get yourself in trouble based on what we're just about to talk about here in Senate Bill 118. This is what Senate Bill 118 does, though, with respect to the records that are already required to be produced. Again, first, it just simply recodifies that you are obligated to produce records upon a request. But then, as you can see in number 1, the association may redact Social Security numbers, bank account numbers, or any communication that is attorney-client privileged may be withheld from a document request. This implies, as you can see in my note here, that owners can request a copy of violation letters sent to other owners. Because if you can redact Social Security numbers and things like that, that's actually getting very specific and targeted as to the record being produced. And the justification or the explanation as to why you as an owner can come to the board and say, I want a copy of all violation letters sent out to everybody else in the community regarding improper parking. The board's first inclination usually is, we don't want to, for privacy reasons, we don't want to disclose whom we've sent warning letters to or who we find. But the greater policy concern that's behind all of this is that if you feel like you're being picked on, you should be able to find out if other people have had violation letters sent to them for the same type of behavior. Again, parking. If I get a notice that says, changing the example just a little bit, that my boat needs to be removed or I'm going to get fined, and I don't move it within 48 hours or something, I get a big old $500 fine or something. And I just got a gut feeling that no one else has been fined for boats because I can look around and see them. They're all around the neighborhood. I have the right to ask under this other records provision of the code for those other enforcement letters that were sent out. You may or may not be able to redact people's names, but the issue here is that I'm entitled to get probably a level of records that are more detailed than many board members thought when an owner starts to request them. And that's simply, in this case, in this hypothetical, for an owner to prove whether they're being picked on or not being picked on. And so the documents would bear that out. If we go on to number 2 here on this current slide, an owner's request can be to A, personally inspect records themselves, B, copy the records themselves, and they can even say, hey, I'm going to bring a copy machine. I don't want you to do it because I don't want to spend any money and have you or your staff do it. I've got a little portable machine. And if they say that to you, you have to provide an adequate place, space, lighting, and power so that I can use my copy machine and get my job done. Or another option is I can say, make a demand upon the association that they copy the records that I've requested, and I have to pay 10 cents per page and $15 an hour for the document request that I've just made. The final way that I can get records is tell the association that I want records A, B, C, D, E, F, and G, and that because there's so many of them, I'm going to have a copy service come out and make copies for them. The association is going to have to accommodate that, and I have to pay the cost directly to the third-party vendor that's making those copies. So there's a lot of issues to work out there. The scope of the records that an owner is entitled to is pretty broad. Privacy is probably not as protected as most boards think, and that's solely to make sure that owners can prove their innocence or condemn themselves, basically, if the association is, in fact, sending out letters and fines and things like that. That will come to light through a document request. Here's the bigger part of the current bill, Senate Bill 118, is what happens if the association fails to comply with the request. The first step, remember, is your board and your attorney or your manager are going to have to discuss the situation when they get a document request and determine if it's an appropriate request or not. And that's an analysis in and of itself. But let's assume that the request is proper, then and the association, for whatever reason, still refuses to do it, produce the documents, that is. Well, the statute now reads that the association shall pay reasonable cost of inspecting and copying the requested documents, which are going to be the photocopying charges and labor charges, and B, reasonable attorney fees and costs incurred in obtaining the inspection and copies of records. So this is where there's quite a change in the law here, because number 2 assumes that by efforts, perhaps even with an attorney, you've obtained the records. And that does not necessarily mean that you've filed a lawsuit. That means that an attorney's written some demand letters and finally worked it out with the association to produce records. The challenge here is that the attorney may then send the association a bill. There's been no court order or ruling awarding attorney fees. This is how the statute reads: reasonable attorney fees and costs incurred in obtaining the inspection and the copies. So the moral of the story is make your analysis up front whether the request is proper or not, and if it's proper, produce the records. Don't dispute it, because if an owner has to hire an attorney, there's a very high likelihood the association is going to end up paying something for the letters and such that the attorneys had to draft to compel the procurement or obtaining the records. And as you can see, number 3 here, number 2 above, both expressly and implicitly presume that ultimately the owner obtained the requested records. And as I just mentioned, usually that's going to be because an attorney was hired and made some demands, and they're going to come back and say, well, I want some money to pay my attorney back. That's going to be a new issue and a hot topic that we're going to have to confront and address as those of us who are looking out for associations. Again, my advice is let's simply not deny record requests in the first place that are proper requests. Here is, on this next slide, the penalties that are in addition to that previous penalty. That previous penalty was simply, I may be responsible for some attorney fees if we improperly deny someone record. The other penalty is that the association can unfortunately be sued. Now remember, as we're going to discuss in just a moment, these statutes come about primarily because an owner has had a bad experience with their association, has gotten in touch with their legislator, and these bills come to the forefront, and the legislator wants to take care of its constituency and puts forth some bills that put this punitive language in there. We get involved with LAC, or the Legislative Action Committee, to help monitor and regulate these situations to make sure that A, the penalty makes sense, and B, that it's not too onerous. And by making sense, I think everyone would agree that if you're an owner should be entitled to records. So our job is to help you, as attorneys, I guess, speaking as an attorney, our job is to help boards make sure that they understand what records are to be produced and what happens if they don't, so we can avoid this situation entirely. But in the worst case scenario, let's say that the association just adamantly does not turn over any records, and they were supposed to, but they didn't. Then the owner must give at least 10 days written notice, evidencing that they've made prior requests and stating how those requests have not been fulfilled. And then the bottom line is, after 10 days, if the association has not decided to comply with the written demand, that is the trigger that allows the owner to file a complaint with the court. And they're entitled to $500 or actual damages, including attorney fees, if they have to compel the production of records. And the result of that lawsuit would be a court order saying that the association has to produce records. So that's just somewhere you don't want to have to go. And again, it's all about analyzing the initial request, and if it's a proper request, not playing games with the situation, produce the records as appropriate. Even if you don't feel that you want to give that information out, one of the primary points of this statute and my presentation tonight is, even though you don't want to, sometimes you have to. And that's the message for most of my presentation. And then what happens if someone does file a lawsuit, the statute now says that if somebody files a motion to compel the production of records after a lawsuit's been filed, the motion shall be, a hearing shall be held within 30 days of the motion being filed. So it's a pretty expedited process. And it is what it is. And I have, to be honest with you, I have feelings on both sides of the table on this one. I would hate to be an owner that's not getting records. And if I'm not getting records, I should be entitled to them, and there should be a penalty for the association for not producing them. I fully understand that. On the other side of the table, as representing associations, we want to maintain the integrity of privacy. We want to maintain the integrity of our structure and our governance, and we don't necessarily want people peeking behind the black curtain to figure out how we operate. But when I think of it in those terms, there really shouldn't be a black curtain at all. This bill is about transparency, and when I think of it that way, some of my concerns as a homeowner association attorney go away. So remember that an association avoids these consequences if it produces records timely and properly. I know I've said that 3 or 4 times now. Also remember, you cannot draft your governing documents around the requirements of this statute. So in other words, you can't put in your bylaws now that a clause that says, oh, by the way, the only records that we ever are going to keep are a balance sheet and an income statement, and if anybody ever makes a request, that's all we ever have to produce. You cannot draft around the statute. The statute trumps and takes priority over your governing documents. So here's my hint to make this so it's not so burdensome. And here's my hint and tip to make sure that associations can deal with this statute effectively, and that is have a document retention policy. You'll need to make sure that it complies with statutes, however, because some records are supposed to be kept indefinitely. Others you can get rid of immediately or within a short period of time. So there's not really the need to have boxes upon boxes upon boxes of documents. You might want to have them for a certain period of time so you can prove what has or has not been done, or that you can prove payments have been made, or the IRS may require that you hold on to certain financial documents for a period of time. But after that, let's get rid of them, and do that by adopting a policy, and your attorney should help you craft that. So that's pretty much all I have to say on the records issue. Remember, there are no black curtains that provide a barrier between owners and the boards. The intent of the bill is to make associations more transparent. I am not saying associations are not transparent. I'm just saying that the concern was that great that folks on the House side and folks on the Senate side felt this bill needed to move forward, and that came from constituents complaining about boards not being transparent. So let's just do it right. Let's avoid the penalties and the consequences, and we can avoid the whole hassle of all that. So moving on to amending governing documents, the other part of Senate Bill 118, it's basically a clarification of what most of you already know, and that is that irrespective of when your association was created, your governing documents after developer control has expired and the membership or the leadership is turned over to the members themselves, the documents themselves, the declaration and bylaws, cannot say or require more than 67% of the voting interests are necessary to amend your documents. In other words, as many of you know, when an association is under developer control, they often put in a 75% or even 100% amendment threshold, and they do that to protect their interests while they're selling. But after they've sold their units and they're gone, you don't need that high of a standard anymore because it just doesn't make sense for your community to operate and to be able to change and to adapt to different living arrangements and situations and other issues that come up in your community. There's got to be a mechanism to make it so you can amend short of 75% or 100%. So this statute for both condominiums and non-condominiums clarifies that irrespective of when your association was created, that after developer turnover has occurred, no more than 67% can be required by the declaration. So even if the declaration says 75%, it's 67% to amend. And remember to read your declaration closely because sometimes it's 67% of all owners with each owner having one vote, or it's 67% of the total voting power where each owner has a percentage interest and a weighted voting situation. Also remember that your documents can have a lower threshold to amend. It doesn't have to be 67%. It can be 51%. The point is, it just can't be, and it will not be from the present statute in existence, and on a go-forward basis. This statute is clarifying that it has to be 67% as the maximum amount of voting interest required to amend. And here's another B on this slide is really important as well. After the declarant control period is ended, the governing documents cannot require the approval of any specific unit owner. So sometimes you have a situation where declarant control is turned over, but the declarant, he or she, still owns a unit. And there's a question of whether or not they can come in with their one vote now, even though at one time they owned all units or lots, 100%. They sell them off, but they still own one. And this says that they can't come in and veto an amendment. They fall into the mix like everybody else under the 67%. C is really important as well. C is saying that for those documents, declarations and bylaws that require lenders who hold a first position security interest by a mortgage or a deed of trust, those documents that say, oh, yeah, you can go ahead and amend your documents, and you might need 67% of your membership, but you need 100% of the lenders to agree to changes to your documents. For example, yeah, go ahead and add a rental restriction. 67% of your members can vote for that. But when a rental restriction requires 100% of the lenders to approve, that's been changed. By statute in Utah now, it's 67% of the lenders. So that's a huge improvement in Utah law because I bet you there are a lot of amendments that have been passed out there by the membership, and 100% of the lenders maybe haven't given their consent. So this helps with that. And as a side note, many of you will know that a few years ago, our committee got a bill passed that says in order to get lender approval, all you need to do is send notice out with the ballot and a copy of the amendment to the last known lending institution. And within a certain period of time, if they do not respond, then it's deemed a yes vote. So now that's one of the rare instances where you can get a yes vote without somebody actually doing something. Usually, apathy or lack of participation is just the same as a no vote. Nevertheless, if you come across a clause in your CC&Rs or your bylaws that say 100% of the mortgagees must consent to this, or it says 75% of the mortgagees must consent to this or that, well, Utah law is now 67%. And then number 2 at the bottom, I think this is really an important provision, and attorneys will know more what this means, and they'll have to perhaps interpret it to you on an individual basis if this arises in your communities. But it reads in the statute, generally it reads, finally, or let me just paraphrase, any provision in the governing document that prohibits a vote or approval to amend any part of the governing documents during a particular time period is invalid. That's a little bit confusing, but here's the general gist of that, and here's the takeaway that I want you to have. Some CC&Rs say that these covenants, conditions, and restrictions are recorded on this day and shall remain in force and effect for 20 years, and then thereafter they renew automatically for subsequent 10-year intervals, something like that. The question arises from time to time whether or not your documents can even be amended in that first 20-year period. If it says, they are hereby adopted on this date and they are in force and effect for 20 years, and then they renew. This provision basically states that if there's a limitation on amending during a time period, that limitation is invalid. So that clears up that potential problem that we sometimes see. Now, the final part of Senate Bill 118, and I appreciate everyone's patience. I know I just tend to ramble on and on and on, and those of you who've heard me speak before have probably gotten used to it, but those of you who are listening to me for the first time are probably saying, John, shut this thing up, let's get going. But hopefully this has been of some value for you. But the last part I want to conclude with is that we tagged on to the end of Senate Bill 118 penalties for failing to hold open board meetings. And as will be discussed tonight, open board meetings, that's House Bill 99, you'll get all the details when that's presented. But there wasn't a penalty. So some of the legislators came to us and they said, well, we'll agree with an open meetings bill. And by the way, once again, look at number one. Please remember that any time legislation is drafted, compromises are required to get legislators to either soften their position or agree with proposed bills. Number two, open board meetings have been a big concern for years with several legislators. Some people are convinced that boards are doing things in secret, and this bill, by that I meant House Bill 99, comes from that concern. And that's, like we mentioned earlier, that's the whole records disclosure. That comes from concerns voiced to legislators. But back to the last part of Senate Bill 118. It was brought to our attention that there was no penalty if the board did not hold an open board meeting, as you'll be discussing tonight. So we tacked on a section here that basically said, and it's very similar to the penalty for not producing records, but it's a little different, but it's similar. So what it does say is that if a board is not opening up its meetings to members as required by the statute, and as will be discussed tonight, then the owners must give the association 90 days written notice of their demand that the board is not following the open meetings law. And then the complaining owner must express what part of the law was, in their opinion, violated. And then, upon consultation with your attorney and your manager and your professional team, if the association does not comply with its written demand and 90 days has come and gone, then the owner has the trigger to file a lawsuit that the board comply with the open board meeting law that House Bill 99 is all about. So this has a much longer tether on it, 90 days written notice before someone has standing to bring a lawsuit against the association to compel compliance with the open meetings law. But again, I hate any legislation that actually tees up a lawsuit against an association, and we all do. However, we have to balance the powers of the board with the rights of the homeowners. And in order to do that, we've had to compromise on some penalties. But I do like the fact that this has a 90-day tether. And by that, I mean, again, if you haven't complied with an owner's request for corrective behavior to open up your board meetings, after 90 days, then they can bring legal action and seek damages, at least $500, and attorney fees and a court order saying that you must open your board meeting. So the moral of this story regarding open board meetings is follow the statute. Follow what we're about to talk about tonight regarding House Bill 99. you won't be in trouble. You won't have to worry about 90 days and written notice and lawsuits. And remember, as you talk about House Bill 99, it's only a very limited owner right to be given notice of board meetings and to attend and have a very limited comment section as part of that meeting. The homeowners are still not the decision makers. It's still the board. But this is a chance, an opportunity for homeowners to feel like things are not being done in secret. So that is my presentation for Senate Bill 118. I hope that is clear as mud to all of you. But in reality, it's just two main concepts. One, follow the records disclosure requirements, and you'll probably need to talk to your attorney about that to make sure you do it correctly. If you do so, you're going to avoid any punitive measures. And then two, follow the open board meetings law. If you do so, you'll avoid any negative consequences. And that's what we here on LAC are here to help you do, is understand what these bills are all about. And your attorneys and your managers and those board members that are listening to this and watching this are being trained to avoid any negative consequences. Remember, this is solely about, and my philosophy is strictly that there has to be a balance between board powers and homeowner rights. And this bill is attempting to find that common ground. So I thank you very much. Look forward to talking to you.
Well, thank you, John Richards. As you may have figured out, John had a scheduling conflict tonight and wasn't able to join us, so we're grateful that he recorded his presentation. And our other two presenters, attorneys Bruce Jenkins and John Morris, have agreed to stick around and answer some questions for a few minutes before we end for the night. The first question came across the chat that their board is holding private, non-open work meetings, planning meetings before board meetings, and then they're having open board meetings, but they're not having any of the discussions. It's just the action items, while everything that was discussed was done privately in a non-open setting. Does the Open Meeting Act cover that kind of a situation? Bruce or John?
You want to take that, Bruce?
I'll take it first, but I'm certain that you'll have something to say because it's a tough one. The reason I say it's tough is the Act only requires the notice of the meeting and the meeting to be open and the participation of the members at a meeting where action may be taken. And at a work meeting, it could be said that no action is going to be taken, therefore no input required, and then at the meeting, where there is going to be action taken, I think, however, input must be allowed, and I would be concerned if the board is stacking those meetings in such a way that they are violating the intent and purpose of the Open Meetings Act, and I would not advise them to do that. I would be reluctant to see them have such a procedure because I think a judge may look at that and say, you're violating this, you're not giving the members the opportunity to be heard, and they're not being able to hear you. That being said, there may be instances when a work meeting or some other chance meeting occurs that is not a violation of the Act. John, what do you think?
I agree with what you said, and I would point specifically to Section 4 of the new Act that says a management committee member may not avoid or obstruct the requirements of this section. And, if you saw that pattern of work meetings where no meaningful discussion is occurring at the meeting, I think a pretty good argument could be made that that's being violated, which would potentially tee up that the risk of both attorney's fees being awarded to someone who challenged that and potentially a penalty.
I think what we see across the country and here in Utah is if the boards try to flaunt this act and the intent of the legislature by, playing these kind of games, by having non-open private work meetings, the legislature is going to just deal with it in the next legislative session. And it's going to end up being worse than if they would have complied in the first place. So I would err on the side of being as open as you could be.
Michael, let me just add to that, because I think your comment is great. I continue to say that if in this industry we do not police ourselves, if we take advantage of members, then someone else will do the policing for us, and we're not going to like that. So I think you're right on. If our boards are obstructing member participation, the legislature will step in and they will fix it for us.
Correct. Can the association produce a members list upon request with the names and the unit-owned addresses while not providing the mailing addresses, especially for off-site owners? Would that comply with the Act? So I've requested as a homeowner a list of all the names and the addresses of the owners, like the Act says, but I'm given, the association just replies with all the names and the physical address of the units owned, not the mailing addresses of the owners. John, you want to start off with that one?
Sure. If the association keeps records of the mailing addresses, and those are asked for specifically under that second part of the Revised Nonprofit Corporation Act, I think you have to provide them.
Bruce, do you have any
conflicting
view?
No, I agree. The issue that I have seen, and I think will come up again, is that section of the Act talks about the addresses. Historically, addresses have meant to us mailing addresses. It does not say email addresses. And where associations use emails to communicate, the question then becomes, is it simply the mailing address that is to be provided, or the email address also? And I know some homeowners have objected to their email address being shared with the collective membership. So I think that is where I see the conflict coming.
Okay. The Nonprofit Act says that if requested, a list of the board and officers and their home or business address needs to be provided. Can the board officer list use the management company's business address as a business address for their contact? Bruce, I'll let you go first there.
I think the Act has to, the information that the Act requires must be given. And if it asks for a home address, you give a home address. If it asks for a business address and you don't have one, then I guess you could give the management company's address as a business address. But otherwise, the information requested is the information that must be given.
John?
So I think your question was, I don't remember the specific terms of the Act, but I think your question was the Act requires one or the other, right? Either the home address or the business address.
Right.
Yeah, in that instance, I think you either have to give the home address or a real business address of the person. I do not think the management company's address would qualify for that.
And I would concur with that.
We've had owners, this is a personal example. We started managing an association about 8 years ago. John, you're familiar with this association. And like 2 weeks after we started managing this association, owners served notice that they were going to come in with copiers, their own copiers, and they were going to copy all the association records. And about 12 homeowners showed up. We hadn't even cataloged all the records. I mean, there was boxes and boxes of them. We'd only been managing them for 2 weeks. And they brought in 3 portable copiers, plugged them in, and copied for 8 hours, every single person, all day, everything that they could find in every box. So the question is, can an association charge a supervision fee, because the association did not want those homeowners being left alone in that room to do that? Can they charge a supervision fee for watching the members while they're doing their copying? And can they charge a fee for the power they are using?
So this is John. The power question under the new statute is definitely answered. The answer is no. You must provide the access to power if they're at the place you provide the documents, if they're going to bring a copier. And I would have to think through the supervision fee, but based on my understanding of this statute, having been involved in drafting it, I'm pretty sure that would not be permitted.
My take on that a little bit is because there's risk of the documents disappearing, that you may, and again, I'd like to look at that more carefully, but you may be able to have a supervision fee. Any fee would have to be reasonable, however, and I've been asked to supervise those, and my association board told me I must charge my attorney's fee rate for the supervision. I told them I wouldn't, and then they fired me, which I was fine with.
But the act talks about a $15 fee for administration of pulling records, I guess. So,
hey, Michael, I'm just reading that section specifically, and what it says is if an employee, manager, or other agent of the Association of Unit Owners makes the copies or electronic scans, and let me back up to the first section. The unit owners shall pay the Association of Unit Owners the reasonable cost of the copies or electronic scans, which may not exceed, and then it's down to this subpart B, if an employee, manager, or other agent of the Association of Unit Owners makes the copies or electronic scans 10 cents per page and $15 per hour for the employees, managers, or other agents' time making the copies or electronic scans. So
yeah,
so go ahead, Michael.
Yeah, so I think maybe we need to readdress that as an industry. And to me, as a non-attorney, that says only if I'm making the copies can I charge that hourly fee. If they're coming in and making the copies themselves, it's silent to that.
That's correct, and I think you're right, Michael. That it's something as an industry we should consider because it does take up one's time to sit there and oversee one making copies, and yet it's necessary to have that done, particularly if you have a fear that someone might alter or destroy a record.
Well, and they're generally not coming in because they're happy. They're right. Coming in because they're upset about something, and I think there should be. We could set that fee by statute. Well, we've gone a long time tonight. Before we ask the last question, I just want to remind everyone that has participated tonight that you'll get an evaluation via email. We ask as a chapter that you please fill that out and help give us input on how to make these webinars better and for you in the future. The last question is on amending governing documents. Even though the law maxes out at 67%, aren't there still times that 100% would be required? For instance, changing the percentage of ownership interest of the members.
I think the law was changed as it relates to the Condominium Act to reduce that to 67% explicitly, and I think that was changed about 15 years ago. So I'm pretty sure that section says 67%, about 80% sure, because that had some interesting effects.
I looked at that, John, just a few minutes ago, and it says 2/3 vote to change the membership interest in the common areas. So that would be consistent. The thing that I've seen from other states is some states, the courts take a strict reading of what it is to mend versus to introduce something new. And as a quick aside, Washington State, their Supreme Court just decided that even though CC&Rs referred to the right to rent and to put a for sale or for rent sign up, that when the community voted and passed according to the percentage requirement of their documents a restriction against certain type of rentals, the court determined that that was not an amendment, but was an introduction of a new term and required 100%. So even though we take great safety in saying it takes 2/3 to amend, I think that we need to be cautious in looking at whether our state will follow some states that say, look, all amendments are amendments, versus other states that take a strict reading and say, if you're introducing something new, that's not an amendment, that's an entire change and requires a different vote. The jury's out in Utah on which way we'll go, I think.
Okay. Well, very good. I want to once again thank Attorney John Richards and Bruce Jenkins and John Morris for their presentations tonight, for sticking around, and Bruce and John Morris especially here till the end to answer some of these questions. I want to thank Spence Bothorpe and Class 1 for putting it together and administrating the webinar through WebEx, and all of you, of course, for attending tonight. Thank you very much, and we look forward to you participating in our next webinar. Have a good night.